You've done a trade, an LC's been opened in your favor, goods have been dispatched, you've locked in your margin. Nothing can go wrong, right? Today I'm going to talk to you about letters of indemnity, and in particular 3 areas. Problems to do with a discharge LOI, problems to do with a payment LOI, and the third area would be solutions we see in the use of LOIs. Discharge LOIs have been used for years. This is simply because goods typically arrive before the documents do, and to avoid the cost of demurrage, sellers typically engage this process of a discharge LOI to allow goods to move before the documents arrive. Now, between 2 parties, that's fine, but the problem is with modern international trade finance, you have a string of buyers in a chain, and most importantly, you have banks who have financed the cargo. And when there is a third party involved, there is always a risk of a misdelivery. Discharge LOIs decouple the movement of the cargo from that of the BL, but traders like to think of a discharge LOI as a substitute for the BL. This is incorrect because it is the BL and the BL alone that can give rights of possession to a third party holder. So, if a third party lawful holder, be it a bank, shows up and seeks delivery or seeks possession of the cargo from the ship owner, this then triggers a chain of events whereby the ship owner will then seek an indemnity from its LOI with the seller, and the seller will then seek its indemnity from the buyer. Unfortunately, in such scenarios where a bank is showing up seeking delivery, it would mean that the buyer is unable to pay and the seller is left carrying the can. That is how the seller has then reintroduced a credit risk on the buyer. When a misdelivery occurs before the BL is obtained, ship owners typically try to allege that the BLs have been spent. This is not correct because the BLs can only be spent if the cargo is released to the party entitled to it. Now bear in mind, the party that's entitled to the cargo might not be the same party that has title under the SPA. It is the lawful holder of the BL which is entitled to delivery of the cargo. And this typically can be a bank that has obtained the BLs only after the cargo has been discharged. The relevant time to look at for spent BLs is the time of which the facility agreement has been arranged with the bank. That is when the rights of it being a lawful holder has been created. So it does not matter if the documents have actually reached the bank later. Those rights have been created earlier, before the cargo has been even put onto the ship. In oil trades, an LC payment worth tens of millions of dollars is paid not on presentation of original shipping documents, but on a payment LOI, which is an undertaking, a warranty by the seller that has good title, and an undertaking that it will provide the BL, the original BL, when it's able to. Pretty amazing stuff, isn't it? I have been thinking about how this risky practice has become so entrenched in the oil trade, and I think it has to do with the oil trades being done on a DES and DAP payment basis on Incoterms. This is when the focus is more on the delivery of the cargo rather than on the documents itself. Strictly speaking, when the buyer gets the cargo, it isn't too concerned about the BL, and I think that's how you have these arrangements where the BLs do not seem to feature in payment instruments. When scrutinized, payment LOIs can produce 3 problems. First, sometimes they are addressed to the wrong party. They are addressed to the buyer rather than to the bank financing it. Second, the bank still needs to find the actual BL to allege a breach of warranty. And the third is that unlike misdelivery claims, a breach of warranty is not as indefensible as it would be for a misdelivery claim. So what are the solutions to the LOI problem? Well, for discharge LOIs, I think it's here to stay. I do not see how you can substitute a discharge LOI mechanism. Ultimately, I think parties need to assess and understand that they are taking a credit risk on the party that's ultimately issuing the LOI, be it the buyer or a third party. For payment LOIs, I don't see this practice surviving very much longer. It is an inherently risky practice. And I think what you might see more of would be, instead of an undertaking to provide a BL, traders would sort of ask for a warranty of title instead. Once again, in oil trades, it is because you're delivering cargo on a DAP or DES basis. It may not be that necessary to present the BL document itself. What is required is a warranty of title. A warranty of title clause solves the issue of seeking to track down the actual BL. But once again, the problem is still there. You need to be sure that the party who has the BL, be it the refinery or the original seller, is holding on to the BL and hasn't used it to double finance the cargo. I hope you found this session useful. I provided a longer update and the link below. Thank you and have a good day.